SJC-12259, Commonwealth v. Moses M. Ehiabhi.
Mr. Hillman, this is the first time that you've already brought the court to tears, and you haven't even started yet. And you may begin.
Good morning, Your Honors. May it please the Court, Zachary Hillman on behalf of the Commonwealth. We're asking the Court to affirm the defendant's conviction and to order the lower court to sentence the defendant in accordance with the statute with which he has been charged and convicted. Since it is the Commonwealth's appeal, at least as to the sentencing issue, I'll begin there unless the Court would prefer me to begin elsewhere. And I think it's important to note at the outset that in Commonwealth versus Cedeno, this court read and interpreted Section 32A, specifically looking at that statute to determine whether or not the statute violated defendant's due process rights because it didn't put the defendant on notice that the conduct was criminal, and the sentence or potential punishment for which the defendant could be sentenced for his violation of that statute, as well as the discretion afforded to a prosecutor in determining which section to charge a defendant with. This court obviously issued its decision and held that the statute did not violate due process. And I mention this background only to highlight that the question that the judge reported in this case presents the same issues. The question as reported by the sentencing judge questioned whether the Section 32A put a defendant on notice for the potential sentence for which he could be sentenced if he violated the statute, as well as the discretion afforded a prosecutor in determining which statute to charge a defendant under.
Is it, I was trying to think of, and maybe you can help me
Yes, Your Honor.
think of other examples where a prosecutor can take the same conduct, the very same elements, and pick between one which has a lesser and a greater punishment.
I think
Because that's really what it amounts to, right?
I agree, Your Honor, and I think the closest analogies that I could perhaps point the court to is one of the analogies that's used in the case law is committing an armed robbery while masked. So in that case, a defendant would be on notice that if he commits an armed robbery while masked, that is a crime, and there is a potential punishment for violation of that statute that includes a mandatory minimum, but a prosecutor in their discretion could charge only so much of the indictment as reads armed robbery.
You know, it would depend on whether or not, I suppose, you could go lower.
Yes, Your Honor.
But I mean, the conduct proven, if it were proven to be with a mask,
Yes.
well, and the prosecutor goes lower, that's a different kind of discretion than if you go higher, right?
If I understand Your Honor's question, I think the analogy here would be in both
But the
instances.
conduct could be different. I mean, if the proof were of a mask, or, or if there was no proof or an inadequate proof of the mask, it could be charged with a lesser included, right?
Yes.
But this is not a lesser included.
Well, it could be charged simply as Class B,
Right.
which would equate it almost as if it were a lesser included. The only difference I can see is if the case were to go to a jury in the armed robbery while masked example, a jury could find that there is no proof of while masked and come back armed robbery.
You couldn't do that.
You couldn't do that here, but that really is a benefit that inures to the defendant, because if the Commonwealth can't prove that it's cocaine, then the defendant is acquitted. The Commonwealth hasn't met its burden. So there's really no discernible difference between the lesser and greater offense example than what we have here.
Isn't the difference, though, Mr. Hillman, that with armed robbery while masked, if that's presented to the grand jury and there's a true bill, there's one possible mandatory minimum. and that's 5 years. Here, the district attorney is deciding between a presentation that has two different mandatory minimums.
Well, yes, so long as there's,
As it relates to the notice issue, if
Yes.
it's armed robbery while masked, I understand that there can be a probation. Put that aside.
Yes.
Armed robbery while masked, the defendant's on notice if an indictment's returned, that's a 5-year mandatory minimum, and that's the DA's choice as to presentation, one possibility.
yes.
Here we have two possibilities depending on the charging decision.
Yes, and I would suggest that there's really no difference in those charging decisions with respect to Section 32A, whether it's under 32AD or 32AB, than you would have with, for example, the armed robbery while masked, or even murder could be an example as well. If there is a murder that's committed with deliberate premeditation, prosecutor could charge the defendant with first-degree murder, and that carries with it the obvious life sentence without parole. Or the prosecutor could present the grand jury with so much of the indictment as charges second-degree murder, and the defendant would be on notice that if he is charged with that crime, he is subject to the possibility of a life sentence, but with the possibility of parole. There's really no difference between the two. There's no distinction between the two situations here.
Can I ask about
Yes, Your Honor.
United States versus Shaw? How is this different from that case where the court found that the two mandatory minimums were inconsistent?
Yes, Your Honor. In Shaw, there was one charge with, and once convicted, two potential penalties. Here, once the prosecutor makes their determination to charge under whatever section they're going to charge under Section 32A, there follows that there's only one sentence. So, for example, if a prosecutor decides to charge under Section 32A, A and B, there's one potential punishment. If, however, the person is distributed cocaine and the prosecutor determines to charge under Section 32A, C, and D, there's one sentencing scheme. That wasn't the case in Shaw. There was two potential sentencing schemes after one conviction.
So how far can this go? So if we have a law that allows penalties for one crime, one set of elements, right? And you can either get this minimum mandatory or this minimum mandatory. Why couldn't the legislature do that and even, make the penalties further apart, say 10 years or 1 year? At what point is it not okay?
Well, I think the legislature, as the arm of our government that determines which actions to criminalize and to set punishments for, can do as they wish within the bounds of due process. I think the scope of the inquiry has to be defined by due process, and here there's simply no question, I would suggest, under this court's own interpretation of the statute, that the decisions made by the legislature, the arm of our government that determines what the penalty should be, there's a violative of due process in this case.
Well, Mr. Hillman, it appears to me that the prosecutor has what has typically been thought to be the judicial function here, is determining what the sentence is. Do you agree that having these two statutes for essentially the same crime gives the prosecutor sentencing power in such a case?
I don't agree, Your Honor, because while the decisions of the prosecutor may...
Well, why not? Because you can have the same crime. I mean, possession with intent to distribute cocaine is the same under A as it is under C. But you can make a choice as to which one you're going to pursue, and that will determine the sentence. The judge has no role in that.
That's true, Your Honor. I agree with that. But that's a function of the executive given to it by the legislature in order to determine which section of the statute it's going to charge under, and that's been recognized by this court as a permissible function of the prosecutor.
Well, where is the rationality in the distinction between the two sections? Where do you see the rationality? How is it rational?
The legislature has made the determination that cocaine is such a scourge to the public that it needs to be singled out along with two other particular substances for harsher punishment, which...
Well, it hasn't, because you can charge cocaine under Section 8.
That's true, Your Honor, but the legislature has provided the prosecutor with the discretion, which is, again, discretion within the as to charging is a vital role of the executive in determining which laws to enforce. It's the legislature's determination that after listening to their constituents and holding hearings to determine that this particular substance, cocaine, is such a substance that it needs to be singled out for harsher punishment. And I would also suggest that while the prosecutor has the discretion to determine which statute to charge under, as it does with many, many other statutes of lesser and greater elements, the judge still holds discretion to fashion a sentence taking into account the mandatory minimum. And what I mean by that is the legislature has set a bottom limit for a sentence for a commission of 32A, C, and D. But the judge still has the ability to fashion a sentence because it provides an upper range. So it's not as if the prosecutor is the only party making the determination as to what the sentence may be. It's only exercising its constitutional authority to do so within the parameters really provided to it by the legislature.
Well, suppose, you're focused on due process. The Macdel brief, I think it was the Macdel brief, the amicus brief, let's just call it that, focuses on the equal protection aspect of this. Now, if the prosecutor, I'm not saying this happens, I'm just, for the sake of argument, were the prosecutor to decide that if it's cocaine, powder cocaine, as opposed to crack cocaine, it'll be charged under A, but crack cocaine gets charged under C. That's okay?
Well, I'll first point out that...
Or suppose this has differences depending on the groups of people who tend to get charged under A or under C.
No, if there was a showing that the charging determination was based on sex, race, religion, that would be improper. That would be a violation of the Equal Protection Clause. Absolutely, Your Honor. That's not what we have in the record before us. The essence of an equal protection claim is that there's been a classification and that there are differing treatments based on that classification. The classification here revolves around the substance, that is cocaine. The legislature, as I just said, made a determination that cocaine needs to be singled out for harsher penalties than other Class B substances. The way that the...
But not always.
But not always, but that's...
That's the question. I mean, when, why? Why in one instance rather than another?
I think the why is within the discretion of the prosecutor so long as it's not doing it for an improper reason.
And how would we know what the improper reason would be? Would have to do some kind of statistical survey?
I think that could be one way. I think I think it was Commonwealth versus Laura, which is, I think that was the case in which this court suggested that there could be a way to make a determination as to whether the police in that instance were pulling over one class of people more than they were the other class of people. But again, that's not what we have here. In addition to the fact that the prosecutor told the judge in this case that if it's cocaine, we follow the legislature's directive to charge cocaine under 32A, C, and D, and this particular defendant was out on supervised...
A directive to charge it that way? I don't see a directive. I just say it sees that you can. It doesn't say it directs you to do it.
No, the statute certainly does not direct it, but by singling out cocaine, the legislature has certainly signaled that it has determined that cocaine is a substance that needs to be treated differently than other Class B substances, and that's why we follow that's why we charge, as the prosecutor told the judge, cocaine under 32A, C, and D. I lost my train of thought there, Your Honor. But I apologize. And also, in this case, the prosecutor told the judge that this defendant was out on supervised release for the very same conduct, which is another factor that added to the decision in this case to charge the defendant under Section 32A, C, and D.
In fact, your office doesn't charge everybody with small c.
There are certainly times, Your Honor, where if a case may be left in the district court, that's certainly true. And there may be times where we exercise our discretion not to charge under 32AC. That's absolutely correct, Your Honor. But again, that's a proper exercise of our discretion in determining.
Under Article 30.
Under Article 30, Your Honor, yes. I see that my time is up. I didn't get a chance to answer or to talk about any other issues. If I'm happy to answer questions.
Oh, we have your brief. Thank you.
Thank you, Your Honors.
Ms. Dolvin?
Good morning, Your Honors. May it please the Court, Sarah Dolvin, here on behalf of Mr. Moses Ehiabhi. Your Honors, the crux of the matter here is that this statute penalizes in two different ways using the identical elements. I don't see that there's any way to get around that.
How do you get around Sedano, though?
Sedano, the decision was in 1989. The statute was amended just prior to that, but obviously after the events in Sedano to essentially get it to its present state. In 1988, I believe C, the cocaine was added, and D was added. But also, looking at the context of sort of doctrinal evolution since then, Amicus pointed out very nicely that there's been subsequent case law that's made clear that the type of substance is an essential element of the crime. So essentially, under Vasquez and McGilvery, if I'm pronouncing that correctly, the statute essentially has 40 different substances, 40 different elements that need to be proven, 3 of which have been singled out and given 2 differing mandatory minimum sentences. And this is where one of our challenges lies.
But I mean, why is that inappropriate for the legislature? I mean, the legislature could say, we don't like all Class B substances, but we really don't like 3 of them.
Well, Your Honor, one simple way to resolve that would have been to remove those substances from the list of the Class B and place them solely under the subsection C. That would alleviate this problem. But again, here we are with...
That may not be so good, because then the DA would lose the ability to drop it down to an A when they choose to.
This is true. This is true.
So be careful what you wish for.
I should. You're right, Your Honor. Thank you. However, there are ways, perhaps, for the legislature to resolve this continuing conflict. And also, the language of the statute itself is ambiguous on its face. Again, if you look at the legislative history, we started with A and B, and then C and D were added. A and B started out as Class B overall, the first offense, and then the subsequent with, I believe it had a 3-year mandatory minimum. And then C was added and D was added, but B was never changed. And interestingly, D is the only subsection of the statute that doesn't use mandatory minimum language. D actually sets up a minimum maximum. B has never been changed, and B applies to this section. And when it was written, it was meant to apply to the whole of 32A. And there's nothing in the indication of any legislative history, nor in any subsequent jurisprudence, that distinctly challenges that B still applies. In fact, I believe the appeals court in Bradley left open, essentially didn't foreclose on the ability for a sentencing judge to sentence under B, even though a defendant was charged under C. Justice Cowan, I believe, in the Suffolk Superior Court, construed this in the Superior Court case. Understand it's not binding on this court in any way, but it was just an interesting recognition on her part that the reading of subsection D really it meant that it had no mandatory minimum, and that it really only dealt with, and the mandatory minimum that applied in the statute was under subsection B. So given all of these interpretations of the statute, I would argue that it's on its face relatively ambiguous. And again, coming back to the issue of these are identical elements in both subsections. You can make an analogy, but it doesn't hold up if you're looking at the armed robbery versus armed robbery while masked. Any analogy to a lesser included, you're sort of ignoring the jurisprudence around lesser included offenses, that one has to have an element that the other does not. Well, here, the elements are exactly the same.
How do you answer the Article 30 issue?
Well, because the elements are exactly the same, it gives the prosecutor essentially and these are sentencing statutes, right? So we're giving to the executive this sentencing capability that should be reserved for the
They have
judiciary.
the ability to charge people with crimes, right?
Yes,
So
they
They
do.
didn't have to charge your client with a crime. That's their choice.
That's their choice, absolutely.
So you're saying that Article 30 would still, they still wouldn't, within Article 30, wouldn't be able to decide which section the legislature has given them, which tool to use to charge?
Well, the executive has the discretion to choose how they charge, what crimes to charge, what crimes not to charge. But again, in this situation, they're given this discretion with two identical crimes. And it's not just, it's a discretion that has a mandate on the judiciary in the form of these mandatory minimum sentences. There, as was evidenced in the record of this case, there is no policy per se. The prosecutor, when asked, did say, well, we tend to charge cocaine more, but she conceded that there was no established policy in her office.
Can I go back to your B and D argument? Where is the ambiguity if it's pretty clear that if you're charged under A for the substantive offense, you're going to sentence under B, and if you're charged under C, you're going to sentence under D. So what's the problem with that? The judge isn't confused about what she's supposed to do.
Well, Your Honor, again, I would argue that the language is a bit confusing between those two sections.
What's confusing about it?
Well, B, again, looking through the legislative history, arguably still applies to the entirety of 32A.
Because you're saying that has to do with any person convicted of violating this section?
Yes.
As it's the only one of those paragraphs that uses the phrase "this section"? And so the section, would you in your construction, means A, B, C, D?
Yes, and given the legislative history in terms of when it was written to apply to the entirety of the statute, and it was not changed as the subsequent subsections were added. And there hasn't been any conclusive jurisprudence about whether or not it does or does not apply still to the entirety of 32A. And again, strangely, D is the only section that uses different language, doesn't use the words mandatory minimum sentence, but really refers, I think Justice Cowan in the Saunders case described it best as sort of a minimum maximum range, which of course a lot of statutes contain that without using this minimum mandatory language. But again, it makes for some ambiguity about where the sentencing parameters are. I
Are
think.
you saying that Cedeno was wrongly decided?
Yes, I think given, especially given the 28 years that have evolved since then, the Vasquez and McGilvery sort of clarification of each of these substances being an essential element. Also, to put this case in context, recognizing perhaps these issues weren't preserved, but they're important nonetheless, that this court recently addressed the issue of the disparate effects of mandatory minimum sentencing for drugs distribution in the state of Massachusetts. And I think that is an important fact to keep in context when thinking about this. This is information that's come to light, probably been going on for much longer than 28 years, but since Cedeno, clearly. 75% of these drug distribution mandatory minimum sentences are handed out to people of racial and ethnic minorities. So it's
It'd be nice if we could consider that, but we can't because it's not in the record.
recognizing that it's not in the record, Your Honor. I would still suggest that it's a context under which this needs to be considered, as in Lalta Prasad. As I understand that case, the constitutional issues weren't preserved in the record, but the court still saw fit to bring that forth through footnotes and make note publicly of the importance of those concerns.
If I can go back to an argument which I don't recall being in your brief, but you referenced then Judge Cowan, is it your position that D is not truly a mandatory minimum except to the extent that you can't go below the mandatory minimum in B because you could arguably suspend some part of that? But how would that work?
Your Honor, that was an argument that was not contained in my brief, that was contained in amicus. I believe that if you follow Justice Cowan's, Judge Cowan's argument, that's exactly it. That
So she's treating it much as we did say for the home invasion statute, which it's a minimum of 20 years, but it's not a minimum mandatory of 20 years. It can be suspended.
correct. And again, looking at the record of this case, this is a situation where my client had one charge on his record and nothing else. And in a situation like this where the statute is ambiguous, that the rule of lenity was properly applied in this case.
So, counsel, do you think that there was any reason, any good reason for the legislature to do what it did?
Without getting political, this statute was amended. It was introduced in the early 80s and amended throughout within a context of a lot of drug war kind of policies going on throughout the country. And I believe that was during that time sort of the people became aware of the prevalence of crack cocaine. However, I disagree with the way that the legislature has presented this. I think this was a sort of ad hoc adding on without sort of looking at the broader picture of how we should be handling these drug convictions.
So it wasn't accidental on their part? It wasn't just, whoops?
Well, it could have been accidental. It's interesting that, again, with the language as you're reading these and knowing the legislative history that we went with A to B, then C and D, that if you do read these, it can be interpreted as, it doesn't seem like they read back very carefully when they added these new subsections on.
But we're stuck with that, though, right? We can't read it out of the statute. We have to interpret it the way it's written.
We can't read it out, and yes, Your Honor, it's as the judiciary, you're bound by the statute to the extent that it satisfies due process. And then, obviously, you have the ability to say to the legislature, you need to make a change in this statute. And when that possibility is ripe, as it is here, the application of the rule of lenity, as the judge used in this case, was correct.
Well, there was an invitation in Cedeno to, I guess, defense advocates to come up with some reason for saying that this discretion is inappropriate. And it's been 28 years, and the defense bar hasn't come up with anything. So what are we supposed to do?
Well, again, as a member of the defense bar, coming to you and asking that in these recent cases where it's becoming clear that we do need to contextualize these statutes. We need to look at how they impact our society as a matter of public policy. And again, recognizing my limits with regard to the record, that these cases have a disparate impact on these convictions under these subsections have a disparate impact on a certain group of people. I see that my time is up. For the rest of the issues, I rest on my briefs. Thank you very much.
Okay, thank you.